As we get to the end of our lessons talking about registered title, I want to talk about the concept of priority because it's going to crop up quite a lot in future lessons' time. And so what we'll do is we'll talk about priority in this lesson, and then in the final two lessons we'll talk about one of the more complicated issues when it comes to registered title and registered title conveyancing, which is this idea of interests which override a registrable disposition, overriding interests which do not exist on the land register. We'll talk about the process in which this is actually operationalized, essentially. So, like I said, this lesson is going to talk about the general rules for priority when it comes to protected interests in the registered title system. Now, for those of you who want a specific citation, we will get to looking at this specifically in this lesson. But the concept of priority and the concept of registered interests in conveyancing is essentially an examination of sections 28 and 29 of the 2002 Land Registration Act. So we've talked about priority before, and it's something that is quite difficult for some, well, at least some newer law students to really get their heads around, because really what the idea of priority is essentially an idea of a bit like a queue of interests which exist. Okay, some interests take priority over other interests, simple as that. Now, where this happens, where one interest takes priority over another interest, the interests which take priority are the ones that will be binding onto others. And so when you talk about the process of land, like land exists for a very long time. So we have a registered estate. Let's say we have a registered estate that has existed for 50 years. And throughout the process of this 50 years, there have been multiple different instances where there have been new interests registered, where there have been conveyancings, where there have been new owners. And these are all dotted all across this timeline, okay? And the idea here is that the newer interests will be bound by the older interests. And so this is only circumvented if the newer interests can take priority. Now, we'll get to how this works in a second, but it gets interesting when we talk about which interests take priority in the course of a registered disposition, in the course of, for example, a conveyance, where a new purchaser comes and transfers title over. If a new purchaser takes ownership of title, which of the interests will they be bound to? I.e., which of the interests will take priority? Are there interests that exist before the conveyance that will have to be adhered to by the new purchaser? Well, if it is simply a temporal list, if it is simply temporal, that essentially every single interest that came before the new conveyance will bind them, then every single interest which came before the registered disposition will take priority. But it isn't, okay? And this is really where we get to sections 28 and 29 of the Land Registration Act. Section 28 says the following. It says that, except as provided by sections 29 and 30, the priority of an interest affected a registered estate or charge is not affecting a registered estate or charge is not affected by a disposition of the estate or charge. It makes no difference for the purposes of this section whether the interest or disposition is registered. So it looks here like where there is a disposition which takes place, the basic idea of priority is unchanged. So where a disposition takes place, where a conveyancing takes place, the interest affecting a registered disposition, a registered estate or charge, is not affected by the disposition on that estate or charge, and it makes no difference whether or not this is registered or not. So it seems like priority is pretty straightforward in this regard. However, as you probably see the switcheroo in the legislation, it says here, except as provided by sections 29 and 30. Well, let's go to sections 29 and 30, mainly 29. We'll spend most of our time looking at 29 because that's where there are exceptions to this ordinary rule of priority. The ordinary rule of priority is this temporal nature of priority, where anything that is before, that comes before the conveyance will bind the new purchaser. But if we then go to the exceptions, we'll then see how this is changed, and how essentially a conveyance will jump the queue and will get priority over those previous interests. Okay, so section 29 says the following. It says that if a registrable disposition of a registered estate is made for valuable consideration, completion of the disposition by registration has the effect of postponing to the interest under the disposition any interest affecting the estate immediately before the disposition, whose priority is not protected at the time of registration. We'll get to what all of this means in a second. For the purposes of subsection 1, the priority of an interest is protected in any case if the interest is a registered charge or subject of a notice in the register, falls within any of the paragraphs of Schedule 3, appears from the register to be accepted from the effect of registration, and in the case of a disposition of a leasehold estate, if the burden of the interest is incident to the estate, okay, and then etc., etc., etc. What does this all mean? Well, subsection 1 is the most important part of this particular piece of legislation. What it tells us here is that the general rule that we saw in section 28, which was the rule of priority, okay, and it states that there is not an effect on priority during a registrable disposition. Okay, this means that the list of interests are unchanged when there is a registrable disposition, like a conveyancing, for example. Okay, and so when that happens, there is no change whatsoever. They'll be bound to those interests, except for situations which fall under the exceptions in section 29. Section 29 and section 30, but we're focusing on mainly section 29. Section 29 simply says that the basic rule of priority, which we saw in section 28, will not apply where a registrable disposition is made for valuable consideration, i.e. in exchange for some kind of consideration, like you would see, for example, in the law of contracts, something for something else, i.e. mainly the purchase of an estate, okay, and completed through a process of registration. This means that a purchaser will not be bound by the third-party interests, which would have been bound under Section 28, unless a notice has been entered, a restriction has been entered, or the interest has been upgraded to something known as an overriding interest, which we will see in Schedule 3 of the Land Registration Act. Let's go back to Section 29 then. So subsection 1 tells us all of this. Okay, it says that a registrable disposition, okay, so for example a conveyance, of a registered estate is made for valuable consideration, i.e. some kind of monetary value. Completion, if this is the case, and then completion of the disposition by registration has the effect of postponing the interest under the disposition, any interest affecting the estate immediately before the disposition. Okay, so that's any of the third-party interests which exist over the estate. Okay, and it will do so if that priority is not protected. And the ways in which we protect that priority is either through the concept of a notice or a restriction, or the fact that we have the interest being upgraded to an overriding interest, which means we look at Schedule 3 of the Land Registration Act, which we'll get to in the next lesson. That's essentially how this whole thing operates. It's very convoluted and very confusing, but if you explain it and you break it down in this kind of way, maybe reread Section 29 a couple of times to get a better understanding of how it works, that's how the Land Registration Act simply gives priority to the registrable disposition unless there has been a protection of priority. And a protection of priority is done through a notice, a restriction, or mainly a notice, or through Schedule 3, which we will get to in the next lesson. So in the previous lesson, what we did was talk about Sections 28 and Sections 29 of the Land Registration Act. This lesson is going to talk about arguably one of the most important elements of registered estates, specifically looking at the idea of registering interests, and these are ideas that relate to interests which override a registrable disposition. And this refers to Schedule 3 of the 2002 Land Registration Act. We're going to talk about it in a bit more detail in this lesson and in the next lesson as well, because in the next lesson there are actually a few cases that we can finally explore, and we're not just relying so heavily on statutes. So the previous lesson talked about the concept of priority as it relates to registered title, talking about, like I said, the general rule in section 28, which is that when there is a registrable disposition, like for example the conveyance of property, there is no effect on priority. And then this is, of course, with the major exception of any of the rules that exist in sections 29 and 30. We focus most of our attention on sections 29. In this lesson, we're going to talk about the concept of overriding interests, which are interests which may still bind a purchaser in a registrable conveyance, but that do not represent, or aren't represented, should I say, by the land register. They're not actually on the land register, and sometimes these are critiqued as something known as a crack in the mirror. The reason why we do this is because one of the major principles of the land register, if you think back to some of the earlier lessons, is this idea that that the land register reflects reality. This is known as the mirror principle. But overriding interests technically don't reflect reality because they are not on the register, but they are still nevertheless interests which are required to be registered, or at least required to be bound by or to a new purchaser in a disposition. So they are seen as something of a crack in said mirror. We'll explain what they are and how they work according to Schedule 3 of the 2002 Land Registration Act. So let's just think about then. What is an overriding interest? Well, an overriding interest is a third-party interest, just like some of the interests that we see in sections 29, but they are a third-party interest which a purchaser of registered title will be bound to uphold, despite not knowing about the interest, and also despite the fact that they do not show up on the land register. So they are particularly strong protected interests that a third party can have over a piece of land. Because not only are they not known by the purchaser often, but they're not needed to be registered on the land register. They can be overriding in that way. Given that they are interests which overrides the basic mirror principle, they are the highest form of protection that you can give and you can grant to a third-party interest in registered title. So these are outlined in Schedule 3 of the Land Registration Act of 2002, and it outlines the remaining legal interests which will override a registrable disposition, i.e. overriding interests. And what we'll do is spend the majority of our time looking at one example, looking at one of the examples here in Schedule 3. We could spend a lot of time going through every single example, but just like with the idea of conveyance being our sort of case study for dispositions, we will take one of the Schedule 3 interests as a sort of case study for actually how we apply Schedule 3 and therefore how we apply overriding interests. Don't forget, when you are thinking about this in the form of a problem question, and you're thinking about potentially whether or not an interest will bind a purchaser in a problem question, you will have to go through the various different stages of the process looking at registered title. So you would have to look firstly at whether or not the title or the interest, should I say, is legal or personal, i.e. proprietary or personal, i.e. a right in rem or a right in personam. You then think about whether or not that interest can be overreached, and then you may go down the list and go to sections 29, section 30, and see whether or not it is protected by the Land Registration Act there. And then if it is not, you will then go and have a look at whether or not it is an overriding interest in Schedule 3. And this is really where we're at in terms of the general flowchart from point to point in relation to understanding whether or not an interest will bind a purchaser. We will also only talk about one major element of the Schedule 3 provision because the others are either of less important or because they will be discussed in a future lesson. So you will see some of the key words that you will find in future lessons' time being part of the overriding interests. These interests include local land charges, easements and profits a preneur, and also leasehold estates in land, interests of persons in actual occupation. So, We'll talk about leaseholds. We'll talk about leases in future lessons. We'll also talk about easements in future lessons' time. What we're going to examine in this lesson and in the next lesson is the concept of the interests of persons in actual occupation. How does this work? How does the case law interpret this particular provision? And how is this applied in real life? So Schedule 3 of the Land Registration Act says the following. It says that in relation to interests of persons in actual occupation, an interest belonging at the time of the disposition to a person in actual occupation, so far as relating to land of which he is in actual occupation, except for an interest under a settlement under the Settled Land Act of 1935, an interest of a person whom inquiry was made before the disposition and who failed to disclose the right when he could reasonably have been expected to do so, an interest which belongs to a person whose occupation would not have been obvious on a reasonably careful inspection of the land at the time of the disposition, and of which the person to whom the disposition is made does not have actual knowledge at the time, etc., etc., etc. This is a little bit complicated, a little bit wordy in terms of the language. We will start to unpack this in the next lesson in far more detail, so don't worry about that. But as a general summary, what does actual occupation tell us as part of this idea of it being an overriding interest? Well, upon examination of paragraph 2 of Schedule 3, which is where this actually is, paragraph 2, as you can see here stated, we can see that in order for actual occupation to amount to an overriding interest, there must be a priority right, which exists, in conjunction with the actual occupation, and that this must be minus inquiry into the property. So you will have to first have a right which has priority, okay, whether or not it is registered or not, and then this right must exist in conjunction with the actual occupation, a person who is actually occupying the property, and then this must be without the person who is doing the purchasing actually doing a proper inquiry into said property. If all of these things are satisfied, then actual occupation may amount to an overriding interest under Schedule 3 and therefore may bind a purchaser of registered estate. There's extensive case law on this matter, and we'll talk about how the case law interprets all of these different things. So, for example, what actual occupation means, how is this applied depending on the different types of land that we're talking about, all of which we'll explore in the next lesson. In this final lesson, talking about registered title, what we're going to do is talk about the concept and the meaning of actual occupation. This is found in paragraph 2 of Schedule 3 of the Land Registration Act of 2002. We'll explore some of the case law that has been established in an attempt to try and define what we mean by actual occupation and how it can be applied in various different circumstances, to give you a better understanding of how actual occupation can be represented in the various different kinds of land that exists. This is a follow-up from the previous lesson where we looked at the concept of overriding interests in the systems of registered title. We spent a little bit of time talking about Schedule 3 of the Land Registration Act, the concept of an overriding interest, the idea of an interest which will override a registrable disposition, before we turned our attention to the concept that is found in paragraph 2, which is that of actual occupation. So let's look at some of the case law that examines and gives more authority on the meaning of actual occupation, because the meaning of actual occupation is something that is quite controversial, given the fact that it is relatively undefined, or left relatively undefined in the Land Registration Act, and so really it is up to the case law, up to the courts to make a decision as to what is constitutive of actual occupation. We don't have a definition, and so the particular determination of what actual occupation means is determined by the particular factual circumstances. The courts have been relatively reluctant to make strict determinations on what actual occupation means, i.e. defining the borders of what actual occupation is and what actual occupation isn't, coming up with a single unified definition. Rather, they've taken for a more flexible approach. They've been more flexible in their application of what actual occupation means. This is useful in the sense that it allows us to apply the concept to various different kinds of land, various different kinds of factual circumstance, which gives it a more fluid definition, which is of course a good thing. The leading authority in this area is the landmark case of Williams and Glenn's Bank versus Boland from 1981. In this case, you have some land, specifically the land in question is a house, and it was owned solely by the husband in a matrimonial relationship. Despite the fact that in terms of title, the ownership was strictly in the hands of the husband, you see that the wife contributes quite significantly to the asking price of the property originally. So they both contributed to the asking price of the property, and it is registered legally in the name of one of the people, in the husband, which means that the wife has equitable interest in the property by way of an implied trust. We'll get to trusts in land in the next lesson, in the next major topic. Without telling his wife, the husband went on to mortgage for the property, go and get a mortgage for the property, and when the husband then defaulted on the repayments for that mortgage, the bank sought to take possession of the property. Now, if we only recognised the legal interest of the owner, i.e. the husband, then the bank would be entitled to repossess said property. But we have to also take into consideration the fact that the wife had equitable interests in the property because of the fact that she contributed to the asking price, and so repossession is not something that is so simple, because you can remember that because this is a registered title, we can think about the fact that the wife, as the idea of her equitable interest being an implied trust, means that she has some kind of priority over the title. And the question, therefore, is, can it become an overriding interest under Schedule 3? Well, the answer to that question is yes, if we can show that there is actual occupation. So the bank wanted an order for repossession of the property, but it was argued by the wife that she had an overriding interest, and so this could negate said order, and the overriding interest has to be found in paragraph 2 of Schedule 3. So the question that we have to think about is whether or not actual occupation was found. Well, in terms of the judgment of the decision, the wife did have an overriding interest on account of the trust for sale, in addition to the actual occupation of the property, and so the decision itself is relatively isn't as important, shall we say, as the court's discussion and going back and forth and legal adjudication on the concept of actual occupation. That's a little bit more important than whether or not she actually was in actual occupation. So it is useful in the sense that what Lord Wilberforce does is spend some time discussing the nature of actual occupation. They say, for example, that were the wives here in actual occupation. These words are ordinary words of plain English and should, in my opinion, be taken as such. So it suggests here, the suggestion by Lord Wilberforce here is that the concept of actual occupation should just be something that is interpreted not as having any kind of special legal interpretation, but should just be interpreted as the ordinary plain words of English, i.e. actual occupation. Was there a person who is occupying the property, and was there an actual occupying of the property? In this case, taking a literal definition of the meaning of actual occupation makes it a question of fact. It makes it a question of whether or not the wife is actually in occupation of the property. And this is a question of fact, it's not a question of law. And then if the answer to that is yes, then you can make the conclusion that they are therefore in actual occupation. Moving on then, the case of Abbey National and Khan from 1990 is very similar to the facts of Boland, because they have the mortgaging of a property, this time for the defendant with her son, and the claimant is claiming an order for repossession when the son is unable to make repayments, and so defaults on that mortgage. The defendant made the argument that she had an overriding interest and wanted to rely on the idea of actual occupation to make this point very well known. She did so because she claimed to have an equitable proprietary interest. The reason for this is because, just like in the case of Boland, she had made financial contributions to the property. So while her legal title she did not have legal title to the property, her name wasn't on the actual the land register or the property itself, i.e. registered legally in her name, she still had an equitable proprietary interest since she had made substantial financial contributions to the property. She also claimed to have been in actual occupation on the basis that she had moved in some carpets half an hour before the charge was completed. So there is some interest here in terms of looking at the factual examination of the case, examining whether or not the idea of actual occupation is cited here, the concept of moving in some carpets for half an hour before the charge was completed, whether or not this constitutes actual occupation. The court held that she was not in actual occupation, and because she did not have this actual occupation, or she could not prove that she was in actual occupation, she did not have an overriding interest. And the courts again discussed the meaning of actual occupation to try and clarify this case in a bit more detail. They say that in Williams and Glenn's Bank versus Boland, Lord Wilberforce observed that these words, actual occupation, should be interpreted for what they are, ordinary words of plain English. But even plain English may contain a variety of shades of meaning. At the date of completion, Mrs. Khan had not personally been even in England, leaving along with in personal occupation of the property. And the trial judge held that the acts done by Mr. Abraham Khan, the son, and Mr. George Khan amounted to, quote, no more than taking preparatory steps, leading to the assumption of actual residential occupation. So they take the ordinary meanings of the word, and they suggest that there are different varieties of shades of meaning, of course, and then they apply the idea to the facts of the case. They argue that what had been done, the steps that were argued or alleged to have been actual occupation, were just acts in preparation for assuming actual occupation of the residential property, and so as a result of which they could not be claiming to have had actual occupation. In 2002, we get the case of Malroy Enterprises Limited and Cheshire Homes UK Limited. This case may illustrate circumstances where actual occupation may be impossible owing to being inhabitable. So essentially, whether or not if there is a derelict building, for example, or a building that somebody cannot reasonably be expected to be in actual occupation of, what happens then? How can I prove an overriding interest by way of paragraph 2 if I can't actually occupy the property? Well, the facts of this case were where the claimant was the registered owner, of a building. The building was derelict, which means essentially that it was poor condition owing to neglect. It was essentially inhabitable. Okay, and so a third party had forged a transfer of the property to the defendants, Cheshire Homes UK Limited. And the question for this case was whether or not the claimants had the ability to claim they had any kind of overriding interest. It was held that they did have an overriding interest. And the reason why was because the courts wanted to take some time to examine the meaning of actual occupation in a relation to a property that cannot be lived in. Because actual occupation, if applied, given a very strict interpretation, i.e. given a very strict objective meaning of the phrase, i.e. someone actually living in the property, could be quite limiting in terms of the types of property that can exist. Because if you have a different type of property, like, for example, in this case, where you have a derelict old building that can't be lived in, or you have examples of pieces of land that aren't made for being lived in. So a farm, for example, a field. You shouldn't be expected to just pitch up a tent and live there. What does actual occupation mean in those circumstances? Well, they ultimately concluded that where there is some property or land which is uninhabitable, okay, the concept of actual occupation doesn't necessarily require a strict person strictly living on the property, i.e. a strict definition of the phrase. Instead, actual occupation may be satisfied by reference to some physical presence, okay, with a certain amount of what is known as permanence and continuity. This does not mean that they're actually living on the property per se, because, for example, if I use the example that I just mentioned, the idea of a farm or a field, the idea of you having an overriding interest in that field because you are in actual occupation, does that mean you have to pitch up a tent and live there? No, it suggests instead that you should have some physical presence over the property, which suggests some kind of reliance on that property, for example, i.e. occupying the property, and that physical presence should have a certain amount of permanence and continuity. So it's not just you leaving something there with the express intent to come back and get it, but it should be given that there is some kind of permanence and continuity in relation to your presence over the property. That does not necessarily require you to actually be in the property and living in the property. Okay, so the concept of actual occupation, while originally in the case of Boland was taken to have a strict or at least a definition that is found in the ordinary meaning of the terms in English, whereas now in more recent cases, and taking account of the fact that you have multiple different types of property that can exist, actual occupation is a little bit more subjective. It's got a little bit more leeway in terms of how you can interpret what that means. And so this is a very useful illustration of why the statute not having a definition laid down in law is actually quite useful, because it allows the courts to play around with this concept and apply it to the various different facts of the circumstances of each different case, rather than having to rely on the fact that they have to follow the statute to a T.